Hi, my name is Shannon Borden, and I'm an estate planning attorney here in Las Vegas. So in this video 6, I want to talk to you about the other things that come with your trust package. Because we've talked a lot about estate planning and why getting a trust is important, but there are some other pieces of your trust plan that you should be aware of, such as your pour-over will, fiduciary letters, personal property memorandum, separate property memorandum, and memorial instructions. All of these come with your trust package, so I want to give you a brief overview of what they are and what they do. Let's talk about your pour-over will first. When you get a trust takes the place of your last will and testament. In other words, you don't need a last will and testament because your trust, the centerpiece of your plan, covers everything the will does, plus a lot more. But you will also receive 2 other types of wills with your trust package, a living will and a pour-over will. The living will we already discussed in the video on the most common questions that I get from clients, so I'm not going to cover that one here. But to explain a pour-over will, you need to understand how your trust functions. If you think of your trust as a wagon, all of your assets need to go into the wagon. Bank accounts, property, homes, life insurance policies, retirement accounts, investment accounts, everything. All of your assets must go into your trust wagon for the wagon to work properly. And the process of transferring your assets into your trust wagon is called funding. I'll talk more about funding and the funding process in my next video. But a pour-over will is a fail-safe for the funding process. What this means is it keeps us from having to probate any asset that has not been transferred to your trust. So if you forget to fund or transfer an asset into your trust, we can go to a judge and request that the judge give us an order that the asset we missed should be transferred into the trust. And while we do have to go to court to get the order, we don't have to fully probate that one asset you forgot to fund or transfer to your trust. We just get the order and move the asset into your trust. And this is one of the things that Nevada does that a lot of other states don't do. It's just one more layer of added protection to ensure that your plan works the way you want it to without court intervention. I will also provide you with letters to your fiduciaries. Now, fiduciaries are the people you have elected to perform a legal role in your trust. So it's not your beneficiaries or your guardians or other people who have a non-legal role, unless of course you've picked the same people for both roles. Fiduciaries, the people who serve a legal role in your estate plan, are your successor trustees or the administrators, your financial and medical powers of attorney. So those people receive a letter from me to notify them that they might be called upon to serve. It doesn't give them details of the contents of your planning. It simply puts them on notice that you have estate planning and that they might have a role in that planning, so they know what they need to do next. So the letters say something to the effect that you might be called upon to act as, and if you are called upon, here's what you do and how you do it and who you contact. And that would be me, your handy estate planning attorney. So these letters are good for a couple of reasons. The first is that your trust is a private document. You don't have to file it with a court, you don't post it anywhere, and you really don't have to share it with anyone. You don't have to tell anyone that they're in your trust or what they will get. But this could also be problematic if you become incapacitated or die and no one knows you have estate planning. You don't want your loved ones to think that they have to probate your estate. The second reason these letters are a good idea is because the people you have selected for these important roles may not be able to find your documents. You might have moved, it's in a box somewhere, who knows? But what they do know is to contact my firm. I will have a copy of the documents and I will be able to guide them in the right direction. So really all they need to do to get started is to contact me. And that doesn't mean that anyone who wants it gets a copy of your documents. Only the person you elect as the first successor trustee, the initial administrator of your trust, is entitled to receive a copy of your documents. That way you can still keep your privacy even after you're no longer here. But these letters help your loved ones understand that they might have an important role to play, and they can reach out to me if they need help. It's just one more benefit to completing your fully customized estate plan with us that most attorneys and firms don't do. So let's talk a little bit now about personal property and separate property memorandums. So a lot of clients ask me if there's anywhere in their plan where they can make a list of things that they want certain people to have. For instance, if you want your daughter to have your wedding ring, or your nephew to have the tools in the garage, or your best friend to have the Waterford crystal or an antique clock, where do you put that? So I include a personal property memorandum in your binder for just that reason. You get to write your list of who gets what right in your plan. And you can update this list whenever you want. So if you change your mind or family circumstances change, you can change the list and always have a complete list whenever you need it. And here's a pro tip. You don't have to itemize every single personal item in your house. You only need to list the specific things that you want a particular person to have. Now we'll talk more about your personal property memorandum when we go through your binder together, but for now, just know that you have it, so you don't have to worry about it anymore. Now a separate property memorandum is for married couples who have property they want to keep separate from their marriage and community property. So this might be if there's property that one of them inherited that they want to keep in their side of the family, or property that they came into the marriage with that they want to keep separate from community property. This doesn't apply to everyone, so when we build your plan, we'll discuss if this pertains to you or if this is something you might want. And if you're married but you aren't sure how community property works, we'll go over it during your consultation because it's really an important consideration in your plan. A lot of clients have questions about their memorial instructions, plans for cremation or burial. And this isn't a conversation that is comfortable to have with your loved ones while you're still living. In fact, your loved ones don't want to talk about it because they don't want to think about a time when you won't be there. But it's still an important part of your planning. And your memorial instructions are where you get to write down all of your wishes for when you die. Do you want cremation or burial? Do you want to be laid to rest with your family or with your spouse? Do you have a particular outfit you wish to wear? It can get very detailed. And you can share as much or as little as you want. So it's really a plan about what people should remember most about your life. And you get to decide all of this in advance. And like your personal property memorandum, you can change these instructions whenever you wish. So no matter where you're at in time, your memorial instructions will reflect your most current wishes and design. It will keep your loved ones from guessing at what you want and agonizing over whether they are making the right choices for you. It eases the transition of your passing, so your loved ones have the comfort of knowing they're doing the right thing, what you would want to have done. So funding instructions are an important part of your trust plan as well. Now, funding is the term for retitlement of assets. In other words, here we go. This is the same one I've already said, but if you think of your trust as a wagon, all of your assets have to go into the trust wagon for the wagon to work properly. Now, funding is the process of transferring your assets into the trust wagon. So whether you choose a plan where we do the funding for you or a plan where you do the funding with our guidance, you will receive a complete set of instructions on how to fund or transfer each type of asset to your trust. My next video goes into the funding process in greater detail. I hope that this explains a little bit more about the additional documents that come with your trust plan. Again, I know this is a lot of information, and there is even more information in my other videos. It's very easy to feel overwhelmed or discouraged because this process can be confusing and maybe you haven't heard this information before. But please don't give up or get discouraged. Like I mentioned, this is not a do-it-yourself process. It is an interactive process. You aren't supposed to remember everything I've covered in my video series, and you don't have to understand everything there is to know about estate planning. That's my job. That's why I'm here. And that's why so much of what we do together is interactive. Now rest assured that we will meet and we'll have conversations about your planning throughout this process. And if you have questions or need something explained more than once, we are here to help you. I assure you that together, we will make sure that you have all of the knowledge and assistance you need to make the best decisions you can make for yourself and your loved ones when it comes to your estate planning. And you'll feel good about those decisions because I'm here to ensure that the process is as painless and efficient as possible, so you don't feel overwhelmed or discouraged. Don't wait until it's too late. Let me help you today so you and your loved ones have a better tomorrow. Schedule your free consultation with me today. You can schedule your appointment online at www.bordenlawnv.com, or you can call my office at 702-582-9780. I look forward to seeing you soon.